Good morning, good afternoon, good day, wherever you are. My name is Stephanie Quincy, and I'm the Phoenix Office Chair of the Labor and Employment Group here at Quarles & Brady in Phoenix. My practice focuses on employment litigation. Love doing trials and have had a lot of experience with class action and multi-plaintiff lawsuits. Also do a lot of consulting with companies of all sizes on employment issues ranging from discipline, hiring, investigation of complaints, termination, FLSA, ADA, FMLA, Title VII, and now everybody's favorite, marijuana in the workplace, which is why we are here today. A few housekeeping items before we begin. We are applying for 1 hour of CLE credit. I'm sure that's why many of you are here, so hopefully we will get that credit approved. Please fill out the CLE form located at the back of the materials found in the handouts panel of the webinar dashboard. Please complete the form and return it to the contact on the bottom of the document. There is also an HR attendance certification form on the dashboard for any HR professionals who are in the audience, so you can self-report that. All of your phone lines are muted for obvious reasons. You will be in listen-only mode. This presentation is being recorded. I'm sure there are just thousands of people out there dying to see this, so hopefully they'll have access to it on the web after it's over with. But just an FYI. We also send out a survey at the end. It really does help us in refining these going forward, what you want and what's important to you. So if you would just take a couple minutes and fill that out, it would be greatly appreciated. Unlike a lot of presenters, I prefer questions as we're going through the different topics, and I'm going to try to see them. I've got a screen in front of me which you can see. So if you've got a question, go ahead and type it out. Hopefully I will catch it as it comes through. I'm going to try to leave a lot of time at the end for questions, but hopefully we'll be able to address some of them as we're going through it. I think that's all of the official business. All right. Marijuana in the workplace. It was really interesting in putting this together, and I have to thank Cale Johnson, who is an attorney in our office who helped me immeasurably with this presentation. But once we started doing this, it really was interesting to take a look at where we have come on this. I think this is another issue like gay rights, that 20 years ago, things were very, very different, and the tide is changing quickly. So as an employer, you really do have to be aware. This does not seem to be working. Keep going. So we're going to talk about the history, and then we're going to talk about state laws, case law, and then more practical points. I know that there are plenty of attorneys on this call, so I will be going through the state laws and the case law with some speed, because I'm sure you would love to read about those yourself on your own time. But I do want to cover at least the big points with those. We're going to spend most of the presentation talking about how you actually handle these issues. Interesting. So 1970, Congress decides it's going to pass the Controlled Substances Act, where it puts all of the bad drugs on a certain schedule and makes them, highly illegal. Marijuana was put on as a Schedule I drug in 1970. Now, after this was passed, Congress created the National Commission on Marijuana and Drug Abuse to study the health and psychological effects of marijuana, as well as marijuana's impact on crime and use of other drugs. By the way, Schedule I drugs, for those of you who don't know, are things like heroin and meth and cocaine, where there is no medicinal value and high potential for abuse. So marijuana has always been on that schedule federally. So Congress creates this commission because even then they were thinking, hey, maybe marijuana is a little different than cocaine and heroin. The commission took a couple of years and came back in 1972 and actually said, yeah, marijuana is very different than other Schedule I drugs, and rejected putting marijuana on Schedule I. The commission actually recommended decriminalization of marijuana and further research. Congress, of course, rejected the commission's findings out of hand. So that kind of perked along, and we had lots of songs and lots of different societal takes on marijuana. By the way, I'm trying to keep this a pun-free presentation. We'll see how well I'm able to do it, but I'm trying to go with pun-free. So where does this all lead us? Well, in 1996, of course, California leads the way, and they passed medical marijuana legislation. Since then, 32 other states, the District of Columbia, and several territories have enacted similar laws. 47 states have some form of legalized marijuana. Some states, particularly more conservative states, haven't really passed a medical marijuana law like California's, which allows doctors to prescribe marijuana for what they believe is appropriate purposes. It allows, their laws allow very low THC medical marijuana or only for very limited purposes that are identified in the statute. We've kept right on going. 11 states have legalized recreational marijuana use. Right now, almost 99% of the population lives in a state that has some form of legalized usage. So for those of you out there who are wondering why you're having these issues, marijuana is much more prevalent and it's much more legal than it has ever been. Legal in quotes. So what is the federal position on this? Well, the Obama administration, I almost made a joke about inhaling, but I'm not going to do that. I refuse to have any puns. But the Obama administration basically put out a couple of memos that said they are going to defer to the states and allow the states to make the decision about how they want to enforce marijuana laws, and had relaxed enforcement, certainly in states that had legalized it. So everything went along fairly swimmingly until 2017 when the Trump administration took over. Jeff Sessions immediately rescinded the memos saying that there would be relaxed federal enforcement. But after that, everyone kind of thought there would be some big pronouncement, some big enforcement action, and there really wasn't. It was just sort of radio silence with no direction. Trump has said he will leave it to the states to decide how they want to set their own marijuana policies. And he said that he would probably support the States Act bill, which is a bill which basically says states can decide what they want to do with marijuana policy. So from an administrative standpoint right now, it's in flux, but there really has not been any stepped up enforcement or change in policy that's discernible from the prior administration. But in a historic vote just 2 weeks ago, the Judiciary Committee passed the Marijuana Opportunity Reinvestment and Expungement Act. It's always nice when it spells something. The MORE Act, in a 24-10 vote. It is the very first time that a congressional committee has approved a bill to make marijuana legal. MORE actually does a lot more than that. That wasn't a pun, that was just a straight up commentary. The first thing that the MORE Act does is it takes marijuana off the controlled substances list, which essentially ends the federal prohibition. It allocates resources, of course, a lovely tax. You got to know that the government's going to want their bite in doing all of this. So it puts an excise tax on marijuana products, which would create the Opportunity Trust Fund, which would go for a lot of different purposes, including some drug rehab. The MORE Act also clears or expunges prior federal marijuana convictions and arrests and offers resentencing hearings for cases that are still under supervision. It opens up funding for small, legitimate small business. The Small Business Administration would be able to fund marijuana-related businesses, and also provides non-discriminatory protections for marijuana use or possession, and prohibits the denial of federal public benefits based on the use of possession of marijuana. So quite a wide-ranging law. Also ensures that the possession of marijuana has no adverse impact under immigration laws, requires the BLS to collect data on the demographics of the industry. Doctors at the VA could prescribe medical marijuana. This potentially also has a huge impact on the Americans with Disabilities Act. And we're going to talk more about that in the legal section, but it potentially puts the ADA into play on all of the ADA questions that come up in the workplace related to marijuana, both medical marijuana and recreational marijuana. Currently, even in the Ninth Circuit, where I am, I'm in lovely Phoenix, Arizona, which happens to be, we're desperately, I think, trying to get out of the Ninth Circuit, but we are in the Ninth Circuit right now. But even in the Ninth Circuit, The ADA does not protect even medical marijuana users, as marijuana is still illegal under federal law. Can you click it, Dawn? Thanks. Next. State laws. State law is where it gets crazy. And, generally, we try to be very, very proactive and reasonable and come up with policies that are sensical, commonsensical policies, particularly for our multi-state employers. We try to come up with policies that can be used in every state, asterisk, except California. For those of you who are joining us from California, God bless you, as my grandmother would say. You may interpret that however you want to interpret that, but we do try to come up with policies that make sense and that you can have everywhere. I don't think you can do that with marijuana in the workplace. I really don't. There is so much difference in company culture, so much difference in regional culture, state culture, even local culture as to what's going to be tolerated. Even if you are doing, if you are a multi-state company, you may be doing different things in different states, and we're going to get into that when we talk about safety-sensitive positions. And every state is very different. They fall into general categories, which we're going to talk about. But there is a huge difference right now in state law. So if you're advising companies either as an HR person or as a lawyer, just know you always have got to pull up that law. And the other thing that state law, and actually local law. A lot of cities now have ordinances. So that's getting kind of crazy too. And the other thing you need to do is if you looked a month ago, look again. These laws are changing rapidly. There are a bunch of new ones going into effect in 2020. A lot of legislation is currently in state legislatures. And as I said, the federal bill has at least passed the House committee that it was in. State laws can be broken down into a few different broad categories. It's interesting, the slide that you're looking at right now, that middle one that says those that provide protection from criminal charges but don't provide any employment protection. That's really what we call the first generation laws. That's what you saw in California, in Washington, and Oregon. Laws that took away the state criminal penalties associated with marijuana possession and use, but did not have employment protections in it. So interestingly, the states that were kind of out on the front and more progressive with regard to this did not include those employment protections in the initial laws that passed. Then there's been sort of a second wave of legislation that's passed. In Arizona, it was done by voter referendum. So here we even somewhat different in that not everybody, but the voters adopted it. But it does explicitly provide employment protection. So it's sort of second generation law. The second generation laws do have non-discrimination provisions in them. We're going to talk more about that. And we're seeing a third generation. In New York, New York City, Illinois, and Nevada have some new twists that offer even more protections for employees with regard to marijuana. Several state statutes authorizing medical marijuana use certain provisions against discrimination. The following states, you can go through this quickly. I mean, I've got it sort of broken down which states do which. These are the states right now that offer the most protections. And courts have followed these statutes. This is a case that I absolutely love because I think there are some really great instructional points for lawyers, not only who do litigation, but for lawyers who are trying to advise clients in this area with some practical points. Ms. Whitmer worked at Walmart, got a couple of promotions, ended up being a customer services supervisor. And she was rearranging ice in those big, the big containers that have bagged ice in them. So she's restacking it and she hurts her wrist and it's still hurting a few days later. So she goes ahead and reports it and files a workers' comp claim. Walmart has the same policy that all of y'all have, that if you have a workers' comp claim, you immediately go for drug testing. And so while she was being seen at urgent care or wherever she went, she had the drug testing done and she tested positive for marijuana. Showed them her card at the facility where she got the testing done. Frankly, they didn't really seem to care. Again, this was in Arizona, District of Arizona. They called her in and to talk to her about it. And again, she says to the HR person, I'm a medical marijuana card holder. Walmart sort of, you can tell, takes a little bit of time and decides what they're going to do. And ultimately, they decide to let her go, that they are going to stick with the fact that marijuana is an illegal drug, that she tested positive for marijuana, and they let her go. She challenges her termination, and she had initially filed an EEOC charge, but what was really the heart of this opinion was a claim under the Arizona Medical Marijuana Act. And for those of you who are practitioners, I think what was so interesting about this case is it's Judge Teelborg. Judge Teelborg is a fabulous, I think he's a senior judge now, but he is an amazing judge, had a long and storied career as a medical malpractice trial attorney, a Bush appointee. So, somebody who you think probably would be saying, yeah, if somebody's smoking a little dope, an employer can still say, no, that's not for us. But what the judge did is he really put Walmart to their paces and found that there was a private cause of action under the Arizona Medical Marijuana Act. Otherwise, the entire act would be meaningless. And what the act said is you cannot be fired for being a card holder or merely testing positive for marijuana. There has to be something more. And in that case, there was, and we're going to talk a little bit more about it as we go through a little bit more. Other states, by the way, impose more restrictions on an employee's ability to terminate or even rescind a job offer for a positive test. Nevada, New York City, Massachusetts, these are going into effect. I expect them to multiply just like the flu does. This seems to be the next trend in the law, that laws are being amended to say you can't even test for marijuana. And to the extent you do, you can't rescind any offers based on it. Some states allow employers to terminate employees for testing positive for marijuana, even though medical marijuana in some form is available for prescription in the state. And now in Colorado, even though recreational marijuana is legal, in Colorado, you can fire an employee simply for having a positive drug test. Again, it's that first generation law. There was a case, Coates versus Dish Network, where Mr. Coates, again, tested positive for marijuana, and Dish Network fired him solely on that basis. He challenged it, and the Supreme Court of Colorado said it is still illegal under federal law to use marijuana. Therefore, you are not engaging in lawful off-duty behavior, and if an employer chooses to fire you for that, you can, specifically noting that their first-generation statute did not provide employment protections. It provided for decriminalization under state law, but didn't provide any employment protections. So you look at this list where, as an employer, you can fire people merely for testing positive, and there's some surprises on it. California, Colorado, Oregon, and Washington, to name a few. But again, almost every one of those states have current legislation pending to fix this problem, to add the protection for employment. But right now in California, perfectly legal under state law to fire somebody for testing positive for marijuana. Colorado, same thing. Now, I will tell people in California, everybody, let's all go to law school in one quick sentence. It depends. Do consider what you are doing, what the circumstances are, what the situation is. I was shocked when I did the preparation for this presentation and found out that in California, this is the case. I don't expect it to be a whole lot longer, and there are tweaks and quirks to it, and any judge who can find a way around it probably will. In the following states, employers may be able to lawfully end employment based solely on a positive drug test. Here's another list. Again, a lot of states that appear to be more conservative states that still don't have don't have legislation, though they may have bills pending. And in some states, it's kind of unclear exactly what the status is about whether you can fire somebody merely for testing positive for marijuana. I do want to add, by the way, even with these statutes, and I know I have a slide where we're going to talk a little bit more about this coming up, even states that have legalized recreational marijuana, states that have medical marijuana, you can absolutely positively fire someone for being high at work. You can absolutely positively fire someone for possessing marijuana at work, for using marijuana at work. No state has legalized that. And so really the question is just the test alone. Here's an example of a couple of states. Arizona, as I said, again, we had a voter referendum, so it's been a bit of a mess trying to get all of the statutory language and the regulations in place. But Arizona has a pretty standard provision to what you will see out there that provides employment protection. Delaware, very similar. Again, Connecticut, very, very similar. There are carve-outs, and we're going to talk about that. There still are safe harbors for employers. If you would lose a federal contract for this, if you, in some way your business would be impacted that way, you may be able to exempt out completely from these laws. That's a different presentation. Safety-sensitive positions, which we're going to talk a lot more about. But these statutes are pretty typically written. Here are the states that have passed medical marijuana but have been silent with regard to employment protection. Washington, California, Michigan. So those states have the first generation laws, although again, they are expected to be amended. Who knows how quickly. So the third generation laws we're seeing in places that are more progressive tend to be more liberal jurisdictions. New York City. By the way, New York City I think should relocate to California. Maybe they already have, but love them though. I mean, they're awesome, and these laws actually, when you learn about them, make a ton of sense. For any of you who are in New York City, the New York City website is really, really helpful. They have wonderful training materials there on sexual harassment and other subjects. And there are a lot of types of discrimination that are already banned under New York City law that are not anywhere else in the United States. But again, they tend to be trendsetters. I mean, there are things like ethnic hair. You cannot fire someone for having a traditional hairstyle in New York City. Lots of different types of discrimination are illegal, and New York City went even further and said, we are not going to allow employers to test for marijuana anymore. They have some carve-outs. Police, if it's a police officer or a position with law enforcement, you can still test those folks. People who are inspecting buildings for the city of New York can still be tested for marijuana. Any position requiring a commercial driver's license, and we're going to hit on that in a bit too, because those are a lot of the questions that I get from y'all are driving. What do I do about somebody who drives as part of their job? Can I still test? Can I still hold them accountable? Can I still fire them merely for a positive test? So New York City says a commercial driver's license. D, I think, is really important too. Any position requiring the supervision of or care of children, medical patients, huge issue in the healthcare community as to how this is all going to settle out, or vulnerable persons. And then E, a health and safety position, some sort of the safety sensitive position. And we've been waiting for regulations from the city of New York to sort of flesh out exactly what these positions are going to be. Haven't seen them yet. But this is, the reason I'm spending so much time on this is I really do think the law is going this way. I think you're going to see this more and more and more. New York City has adopted it. Nevada has adopted it. Next slide. Illinois has kicked it up a test as well, kicked it up a notch as well. In their statute, which legalizes recreational marijuana, not only are there protections for employment, part of the protections are you have to set up a dispute system where if you're firing somebody because they are intoxicated or under the influence at work, they have to have a reasonable opportunity to contest the basis of that determination. A little more on the Illinois law. You can create a zero tolerance and drug-free workplace policy. You can ban allowing people to bring even medical marijuana to work with them. They can't be under the influence of it at work. Drug testing is still okay as a means of enforcing the policies. And you can discipline employees for violating the policy by having marijuana in the workplace or being under the influence. What you can't do is take adverse action against an employee for off-duty marijuana use, which would seem to indicate that a positive test, well, it doesn't seem to indicate, positive test is not enough. Ain't gonna get you there, which is the whole Whitmer versus Walmart case that we are gonna hit again. And in Illinois, you also cannot discipline an employee without giving them a reasonable opportunity to contest that they were under the influence of marijuana in the workplace. Question, and this is a really good question, does possessing marijuana at work include having it in your vehicle in the company parking lot? That's a really good question. And I would say yes. I mean, that's company property. I don't want it at work. In the state of Arizona, we love our guns out here. For those of you who are not in Arizona, we love our weaponry. And we actually have a law that if you do not allow employees to bring their guns to the workplace, you have to allow them to keep them in the car. Because apparently if there's a bad guy, someone's going to sprint out to their car, get the gun, come in and shoot him, and it will be great. Sorry, political commentary. I will withdraw that political commentary. But yeah, I would think somebody who has dope in their car, that's a bad deal. And you could certainly prevent them. Now, I'm sure we'll get some legislation on that. We may get some laws on that. We also will get some court rulings on that. And where we see some action in this particular area is in the administrative area. People who are applying for unemployment benefits, people who are applying for workers' compensation benefits. I'm not aware of anything that has answered this question from a legal standpoint, but it would seem to me that the better reason would be you can't have it in your car. That's on company property. And we're going to hit on policies. That's an excellent point to have in a policy, that possession of marijuana includes all company property, including parking lots, including lockers, including everything. Another question. By the way, the next webinar we'll be using your cheaters as a nice little hair appliance. Does this include pre-employment testing in Arizona? And I know some of my colleagues from Illinois are in the audience. I believe in Illinois, you can still test for it, but you can't exclude somebody for a positive test. Which brings up the question we're going to talk about later, which is, do you even really want to test for it in some of these states, depending upon what the positions are? So I would say that's kind of a multifaceted question, which hopefully we'll get to later in the presentation. Okay, case law. Case law providing employment protection, number of cases. And if you look at the dates of these cases, again, I think you're going to see a difference in the trend of where the courts are going. Some of the earlier cases were under some of the first generation statutes. And so they tended to be much more employer friendly than the later cases that we're seeing. But where a state specifically provides for employment protection for medical marijuana users, courts have found a private right of action, even if it's not specifically mentioned in the statute. This would be Arizona specifically. By the way, that case, it is a long case. It is a really long case to read, but it's a great read if you're a litigator. Judge Teoborg, as I mentioned, was a fabulous trial judge. And he really criticizes Walmart for the evidence they presented and some of the discovery exchanges between counsel. Some really great examples in there if you're interested. Chance versus Kraft Heinz Foods in Delaware, and Nofstinger, I'm not Niantic, let's just call it SSC Operating Company in Connecticut, also provided that there is a private cause of action under state law. Here's Whitmer again. We've been through this, so I'm just gonna hit it a little bit more. Something I didn't mention earlier that I think is really important in this case, she tested at the highest detectable level. I think this was something that Walmart thought would be really persuasive to the court. Because again, our statute really looks for impairment. How do you prove impairment of marijuana? This is a huge mess, to be candid with you. With alcohol, it's really easy. Somebody does a blood test or a breath test. We have objective standards. My God, we've got laws on the books in every state as to what constitutes impairment. Alcohol is really, really easy. Marijuana, not at all. Not at all. And Ms. Whitmer detected at the highest possible detection level for THC. So I think they thought, yeah, a court's going to find that based on the fact that she had the highest possible level detectable, that she was impaired. Walmart had no other evidence that she was impaired, none. And we're going to get to that and talk about it. But unfortunately, you're going to have it. There's a couple companies out there that claim they have perfected a test that will detect impairment. Keep in mind, and I don't want to get too deep in the, oh gosh, I almost said it, too deep in the weeds on this. There's one pun, someone keep a score. But the way THC is processed by your body is different than alcohol. THC is stored in fat cells, takes a lot longer to burn off. It's harder, it's different with every individual. It doesn't necessarily tell you when it was ingested, what level it was ingested. It's just a very, very different drug. But there are companies out there who are claiming that they have almost perfected and are testing right now a saliva test that will detect impairment. Buy stock in that company. If make sure it's not Theros first, but buy some stock in that company if they have, because obviously the police are very interested in this too. More on that in a minute. But anyway, poor Miss Whitmer, she tested the highest detectable level, and so Walmart cans her. Well, there's all this back and forth, by the way, after the lawsuit is filed between the attorneys about whether or not they will be claiming that she's impaired based on this test. And the plaintiff's attorney, Miss Whitmer's attorney, who by the way is a delightful guy named Josh Carton, is basically saying, hey, I need to get an expert. If you guys are going to be claiming that she was impaired, I need to get an expert to come in and testify that that reading doesn't necessarily mean anything. And Walmart's attorneys are saying, no, that's not what we're going to say. We're not saying impairment. And then they kind of did say she was impaired, which Judge Teelborg, as somebody who remembers very, very much what it was like to practice law, did not appreciate. In any event, so Whitmer is a great case for many reasons. Established the private right of action, but also sent a strong message to employers that you're going to have to come up with something for impairment. A drug test is not enough. A positive drug test, even at the highest level, is not going to be enough to get you there with impairment. Chance versus Kraft Heinz Foods, kind of similar. I'm going to go through these somewhat quickly, so hopefully we will have time for more questions. Question. Question about the Illinois law. What is a reasonable opportunity to contest? That's a great question. I think different clients are setting it up different ways. There's not a lot of guidance on this yet, obviously. Some of them who already have appeals processes set up or have folded it into that. Others have created their own. It really is unique to each employer, as long as it's something that appears to give the employee the opportunity to present whatever facts may have gone into the particular decision. What is the private cause of action? Lawsuit. You can get sued for it. Okay. Chance versus Kraft Heinz Foods. Knopfsinger. Again, these are just courts that are saying federal law is not going to trump this. There's not going to be a preemption, even if you have a drug-free workplace act. You're not going to have a get-out-of-jail-free card from these lawsuits. Now, some courts have gone the other way. And if you look back, or if you look down this list, there is one case that's from 2019. The other ones tend to be earlier cases. The first case is from Washington. And basically said there is no private right of action in employment law context. In the state of Washington right now, there's a bill to fix this, by the way. California Ross, a case that, boy, you can read a lot about that. Same thing. In California right now, there is a bill to fix this, saying that there is no private right of action. And the city of Lansing, Michigan, by the way, went the same way. I mean, and it's easy to see why. The laws weren't written that way. I mean, you're asking a judge basically to rewrite the law. So no doubt legislatures, city commissions, whatever, will go back and fix these provisions. Next. We're going to go through these pretty quickly again, because I do want to leave a lot of time for questions. Accommodating medical marijuana use. Get a lot of calls on this. What do we have to do to accommodate medical marijuana use? That is really a great question. Under the federal law, under the ADA, you don't have to accommodate medical marijuana use at all. So if you happen to be in a state that has not legalized marijuana at all, federal law doesn't kick in and you may be okay. If, on the other hand, you are in a state that has legalized medical marijuana, yeah, you're going to have to look at it under your state act. Here's a couple of cases, one from Massachusetts and one from New Jersey, that both said, yeah, you got to look at this as an employer. Again, there is nothing out there that says you have to allow someone to be impaired at work, high at work, under the influence, or even allow them to bring their medical marijuana to work. But under state law, as an accommodation, you may have to allow somebody to use off-duty. The case we had in Arizona didn't really address it. It was sort of a skip-over point, but other laws have. What about off-duty conduct? Colorado has a law that prevents employers from taking action against employees for their lawful off-duty conduct. By the way, thanks to my partner who pointed out to me that all of those laws, I think, were so interesting. Fred Gantz, by the way, if you happen to be listening. Fred said all of those laws that were passed many years ago, 10, 20 years ago, that prevent an employer from taking action against an employee for off-duty conduct were brought to us by the tobacco lobby. There was a big push many years ago to allow employers to say, you can't smoke if you work here. And so a number of states, the tobacco lobby got involved, and a number of states passed these types of statutes. But even in Colorado said, hey, it's still illegal under federal law. So if an employer wants to hold an employee accountable for violating federal law, it's not lawful off-duty conduct if it is illegal under federal law. Again, we'll see what Colorado does with this, because they certainly can have a state law cause of action written into their recreational and medical marijuana statutes, and that's very likely to happen. Okay, now the practical pointers. Policies. Can you go back one? Do we have one before that? Nope. Okay. Go ahead. You want to have a written policy. I am not one of those attorneys who's going to say you need to have a policy about where your stapler should sit on your desk. Not a fan of big, fat, huge policy manuals that nobody knows about, and nobody even knows the policies in them. This is one you need, though. If you do not have a written policy on your drug policy and your testing program, you should. And if you are a multi-state employer, you really should have a different policy for every state. You may be able to, group some of them together, but you're going to want a really detailed policy. Most states protect actions in good faith based on the results of a positive drug test, and I'm putting an asterisk there. Someone tests positive for heroin, meth, cocaine, you can just still fire the heck out of them. Alcohol, same thing. You can have a zero tolerance policy for alcohol impairment, totally legal, not even impairment, use. If somebody goes and has a 2 martini lunch or a 1 martini lunch, you can fire them for coming back to work. You can have a policy. Obviously there are issues. You want to have consistent enforcement, etc. With marijuana now, that is different. So put a little asterisk. That's why it says beware there. Actions based on the employer's good faith belief that an employee used or possessed any drug while on the employer's premises, including parking lots, or during the hours of employment. Again, your policies should absolutely say that. You cannot use, ingest, inject. Who knows what it is now? Marijuana, we're going to get to this when we talk about what you have your supervisors document. You can't always just have them document that someone smells like marijuana anymore. Now we've got edibles and liquids and all kinds of stuff based on what my friends have told me. Actions based on the employer's good faith belief that an employee had an impairment while working on the employer's premises. Again, an impairment of any level. Now we've talked about this. For alcohol or any other drug, testing is your friend. For marijuana, testing does you zip good in a lot of states. It doesn't hurt because, obviously the fact that there was a positive test is fine, but it's really going to be more observational. We're going to hit that. Also, your policy should mention safety-sensitive positions, and even better, if you can list out what they are. If you can specifically go through your positions and list out the safety-sensitive ones before you have the claim, that would be awesome. That was another thing Walmart did in that case that was a little when you're working with an attorney and you're going into court and they tell you, that's just one that gives me the bad stomachs, you should always listen, because Tealborg lit them up on this a little bit. That they started talking about how being a customer services supervisor was a safety sensitive position. So that didn't go too far. But if it's listed out before and you're making these decisions in the cold, dispassionate light of not a present situation, and you can put what the tasks are in the job description that correspond to that. So you want all these to match up. So HR people are going to hate me because it's a bunch more paperwork, but you really should revise your drug testing policy to include the safety sensitive positions and go back and redraft those position descriptions. So they've got the skills listed out, the actual duties listed out that are safety sensitive. Next. Again, in every state, it is not going to hurt you from having a written policy. No law allows impairment, possession, or use at work. Okay, here comes a big question, and we danced all around this. Here's the answer to the question. There are no legal levels for impairment of marijuana, unlike alcohol. Unlike other drugs where the mere detection of that drug is in your employee's system is enough to can you. Marijuana use is far harder for lay people to detect than alcohol use. According to medical and scientific experts, there is no concentration level that currently evidences impairment. So we need to have a good faith belief of impairment. And this is from the Arizona, a lot of this is from Arizona law. You're going to see this statute. It's very, very similar in other states that have legalized medical marijuana and have created some rights for employees in the statute. Here's what you're going to want: observed conduct, behavior, or appearance. Information reported by a person believed to be reliable. Somebody who comes and says, I just saw her light up in the bathroom, or she was just laughing in the lunchroom telling me she just had 2 gummies. You want to document all of that. Written, electronic, or verbal statements. Documentation is just going to be really, really key. Lawful video surveillance. We do not want to put the camera in the bathroom. We would rather have the report from the friend who was in the bathroom, but cameras other places. If you've got things that are truly safety sensitive positions, you may already have cameras in those areas. Records of government agencies, law enforcement, or courts. I mean, heaven forbid the police show up and there's a big raid and you've got a guy dealing marijuana off the back dock. Not saying that's happened, but it has. The results of a test, or other information reasonably believed to be reliable or accurate. Here are some symptoms. Employee speech, walking, standing, physical dexterity, agility, coordination. You can read through this list, but basically this is what you need to train your supervisors to be looking for. The person ate 5 bags of Funyuns. I don't know that any non-stoned human has ever eaten 5 bags of Funyuns. I suppose theoretically it's possible, but you want the behaviors recorded. You don't want them to say things like, he acted like he was stoned. You want what the actions are that lead to that. So what do you do about impairment? Again, you've got to train your supervisors. I will also tell you, safety first. Absolutely safety first. If you've got someone in a safety sensitive position and you think they are impaired, get them out of that position. Let's not have anybody hurt or harmed. But again, get your supervisors to document. Tell them to call HR. This is a sensitive area, and there are several different lobbies in this area that may end up funding lawsuits, and plenty of lawyers who are happy to take these kinds of cases. So get HR involved very early and train your supervisors to document. Again, impairment should be documented in detail. There's a lot of slides here. By the way, anybody who wants this presentation, just email us and we're happy to send this out. You can certainly use these parts of the slides to help in your training with supervisors, but these are the kinds of things that we want supervisors documenting. Bloody, glassy, closed, bloodshot eyes, breath odor, potentially if it's an alcohol thing, smell of marijuana, speech, movement, their demeanor. All of those things are what we really want supervisors trained to record. If somebody was involved in an accident, did they say anything odd? Get them corroborated. I mean, if a supervisor is telling you this is going on, have another supervisor come over and watch, have someone from HR come over and watch. If coworkers are bringing this to your attention, have the coworkers put it in writing, and see if you've got any video that might support this as well. Okay, so the big one, there are a couple of big ones. First one is impairment. Nobody can be impaired at work, and we've talked about the difficulty and the challenge of establishing that. You aren't going to be able to do it with a drug test. So you're going to have to do it based on observation. Another big carve out that helps employers in this area is safety sensitive positions. All of these laws have this in one form or another. Some of them have little tweaks to it. Again, you got to read your state statute. You got to know what they're laying out, sort of what the standard is. In New York, it's very, very clear that they consider it a high bar. They did not include someone who just happens to drive as part of their job, for example. It will be interesting to watch and see how that fleshes out because they did include other driving. But safety-sensitive positions allow you to exclude someone who is using marijuana. It'll be interesting also to see how this fleshes out. Because there will be challenges to that, and people I'm sure will say that merely using marijuana is not enough, and you need to find out when that person uses marijuana, if they could still be feeling the effects while they're at work, even if they're not impaired. But in any event, right now, a safety-sensitive position in most states allows you to exclude even a medical marijuana card holder. Again, you want to designate these things. Whoops, can go back. Right now, most of these statutes, as long as you're designating in advance, allow you to include positions which you believe in good faith, which you, the employer, believe in good faith, might affect the health and safety of others. Now, obviously, Judge Tilburg didn't think that was very applicable to a customer service supervisor at Walmart. Here's Arizona law. Arizona goes way further than New York City. Operating a motor vehicle, other vehicle, equipment, machinery, or power tools. Repairing, maintaining, or monitoring certain equipment. Performing duties in the premises of a customer, supplier, or vendor. If you're one of those businesses that sends your employees out to work in somebody else's home and somebody else's business. Preparing or handling food or medicine. And working in any occupation in a particular area in Arizona, which includes the medical profession. So it would seem healthcare right now is, especially in Arizona, but other states as well, is able to largely exempt out of this. What about driving? I get tons of questions about this. If you are if you have a position that requires driving, I would advise you right now to include it as a safety-sensitive position. There are no cases right now that say merely driving isn't enough to get you there. Now, there may be some coming in the future, but there aren't right now. So include it in the policy and the job description. Sort of some interesting statistics about marijuana and driving, for what it's worth for those who are interested. Crashes increased by 6% in Colorado, Oregon, and Washington after they legalized recreational marijuana use. You see who does the study, by the way, to kind of get where the results are going. We thought these were fairly objective statistics. They were not done by the marijuana industry. In Colorado, the number of highway deaths increased in 2017. But the number of drivers in fatal accidents who were legally impaired actually decreased. But that may be just because it's not alcohol anymore. It's difficult to link crashes to marijuana use. Studies have been shown that being impaired by marijuana does affect driving. Big questions remain about the hangover effect, the residual effect from marijuana. That's another area that there just isn't a lot of information on. For those of you who have ever had a drug issue in a case, I had one involving cocaine, and it was very, very interesting, the metabolite of cocaine that remains in someone's system and how you can backdate it to see when they ingested it and how impaired they were. But 2 or 3 days after you have ingested cocaine, you are still a dangerous driver. No question about it. Those studies have not really been done with regard to marijuana. These are with regard to when someone is actually impaired by marijuana. Question just came in. You mentioned driving. Do you have guidance on forklift driving? My guidance would be very careful. Those things are dangerous. And my guidance would also be, it is a safety-sensitive position, driving a forklift. So, nope, sorry. If you are an ingester of marijuana, we are going to say that is not a job you can do. By the way, the question then becomes, under state laws that require accommodation, do you have to move them to a different position that is not a safety-sensitive position? All these fun questions that someday will be answered. Other states have similar exemptions. I gave you what Arizona was. Other statutes are just real similar. We included Oklahoma in tribute to Merle Haggard, for those of you who don't know the Okie from Muskogee song, but I'll throw it in because it's not a pun. Oklahoma includes any job that includes tasks or duties that the employer reasonably believes could affect health and safety, just like Arizona. It includes, but is not limited to, handling, storage, disposal, or transportation of a hazardous waste, firefighting, operating a motor vehicle or heavy machinery, direct patient or child care providers, repairing or maintaining manufacturing equipment, and carrying a firearm. I love this one. We looked in some different areas because they're safety-sensitive position is in some other statutes as well. So we sort of look to see what courts have done with those. And you'll be happy to know that nuclear plant workers are considered safety-sensitive positions. Meter repairmen for gas companies will not be lighting up on the job. EMTs, pipeline operators, and police officers. That's all in a different context, but those have all been held to be safety-sensitive positions. And here are those various cases. We're going to get to this in a second. I'm going to go ahead and click, but these are really, you need to make some strategic decisions when you're deciding what you're going to do with your drug testing program as it applies to marijuana. Here are some things to keep in mind. The state you are in matters. The language of the statute matters. They differ pretty significantly. Even if your statute is silent as to employment protections, you may have ADA state law protections that come into play, or your legislature may change it really, really quickly. Again, no statute requires accommodating on-site marijuana use, possession, or to prevent an employee from being fired when they're high at work. So here are the really practical considerations. Figure out how you're going to regard marijuana. What is your business? If you're in healthcare, you're probably going to have a very different answer than if you're a restaurant. Colorado also did a study on the percentage of applicants who would be excluded from positions if a positive marijuana test was used to exclude applicants. And in the restaurant industry, it was 57%. So very, very different than healthcare or transportation. Ask the folks too who are making these decisions, whether it be your C-suite, your HR team, or whoever, what is the difference between alcohol and marijuana? What is the real difference? Again, the study I thought that was done in 72, that's why I mentioned it. I think it's so interesting. There is such a societal thing. It is just different. Marijuana is regarded very differently than alcohol. And is there a reason for that? Our society seems to be coming to terms with the fact that there's not really that much difference. Do you want to treat it differently? If you are not in healthcare, transportation, or a company that has a ton of safety-sensitive positions, maybe you want to decide you aren't going to treat it differently. And you will continue to say you can't have it at work, you can't be impaired at work, but we're not going to test for it. Are you going to do pre-employment testing? Again, where are you? If you're in New York City, very, very limited the pre-employment marijuana testing you can do. If you are not in New York City or another place that limits it, who are you testing? Because you can make a decision. We are going to deem these safety-sensitive positions, and we are only going to test for those positions. Why are you testing? If you're not going to exclude people who have tested positive for marijuana, do you even want that information? So ask yourself those questions. Look at your policies. You should do it soon. A lot of new statutes are going into effect before 2020. Again, always prohibit using marijuana in the workplace, prohibit being under the influence of marijuana, alcohol, or anything else in the workplace, and define what your safety-sensitive positions are. If you're in Illinois, you need an appeal process. And again, the policy in Illinois should make employees of their right to contest the determination and the process for them doing that. If you aren't in Illinois, do you want to have this? Do you want to have a policy that you allow employees to contest it? Probably depends on the culture of your workplace. Some of my clients say, yeah, why not? I'd rather know up front what they're going to say if they're going to, sue me, or if we've made a mistake, get a chance to fix it. Other employers would say, we're not going there. I don't want to waste the time. But ask yourselves the question. Train your managers. You are not going to be able to fire somebody for a positive marijuana test in a lot of places. You're going to have to show they were impaired. And to do that, you're going to have people testify as to how they knew they were impaired. Next. I think this is all fairly repetitive. Does anybody have questions? I wanted to leave some time for questions. Are there any more slides? Questions? Anyone have questions? Are you getting any questions? Wow, we might actually end early. Let me just go through these really quick and make sure that I've answered it. Give everybody kind of a couple seconds. Ask them now. Free legal advice. All right, I'm going to hang out for a couple more minutes just in case there happen to be any more questions that come in. But that concludes the presentation. Thanks very much for joining us today. Again, thanks to K.L. Johnson for basically educating me on marijuana in the United States in a legal and professional way, of course. And if you've got any questions, please holler. Oh, here we go. Dancers who may be under the influence of marijuana and get injured during rehearsals performance, can they be fired if tested positive? Let me read that again. An employee, specifically a dancer, who may be under the influence of marijuana and get injured during rehearsals performance, can they be fired if tested positive? No. I would say a dancer probably is not a safety sensitive position. And what you would need is to document why you thought they were under the influence. I would also ask your supervisors the question, because why did we wait until she got injured? If we thought she was under the influence, we probably should have stopped the dance before she got injured. In any event, I would definitely say dancer not safety sensitive, so you cannot fire on test alone. You're going to need documented evidence of impairment. Any other questions?
Did you want to talk a little bit about CBD?
Oh, CBD. You know, CBD is becoming very, very interesting. Just a couple quick comments about CBD. I just saw that the Federal Drug Administration sent notices to something like 22 companies. They're really cracking down on claims that CBD oil companies are making regarding nutritional value and health benefits. At this point, unfortunately, however, well, fortunately or unfortunately, it's perfectly legal. It's really no different than using alcohol in the workplace, and you can buy it on any corner. Again, I mean, the tips that we're giving are just such a nice little safe harbor. If somebody's acting funky at the workplace, deal with it. It really doesn't matter why particularly they're acting funky. If somebody's acting drunk or stoned at the workplace, you should deal with that regardless of what made them that way. We'll reverse engineer it later. But CBD oil right now is functionally no different than alcohol. And actually it's in many ways more like an aspirin. I think some people would describe it as something that is a mood stabilizer or something like that. But it's like many other herbal supplements you can buy that are perfectly legal right now. So again, focus on the behavior. Focus on the behavior, not the ingestion of anything that may be causing that. Let's see. Are there any provisions making it a requirement for employees to disclose use medical? Employees usually disclose this and should disclose this prior to a test. Most drug companies have a form people fill out before they take the test disclosing any medications they may be on. Because obviously under the ADA, if they're on any legal medications, those will have to be accommodated. But that's when somebody should disclose it. Other than that, no. There are no laws I'm aware of in any state that require somebody to come out of the box with I'm a card holder or hey, by the way, instead of getting drunk on the weekend, I get high. Next question. You mentioned having different policies in different states. Is it advisable not to test for marijuana in states where it isn't legal just for consistency? I need to know a lot more facts. I need to know whether or not you have safety sensitive positions, if there were differences. But no, you can have different policies by state. I mean, that's perfectly justifiable to explain. In this state, we don't test because state law requires that we don't do that. So I wouldn't worry too much about that. Okay, I'm being told we are at 11 o'clock and there is a cutoff. Or is this a hard stop, or can I keep talking?
You can go a little bit if you want.
Okay, I'm going to answer just a couple more questions. Would an employee in the roofing industry be considered a sensitive position? I would say yes. Falling off of a roof would be a very deadly and dangerous thing. So that one, I would say yes. A roofer is a safety sensitive position. How does this work with drug-free workplace provisions for DoD contractors? It really just depends. It depends on if you are going to financially lose benefits because of it. If you have some financial hit you're going to take, that's going to get you out of most state laws. It really does depend where you are. Again, some state laws, some state courts have specifically held that federal laws, federal prohibitions, do not preempt state laws. So would want a little more information. Another question about what is the current status of Wisconsin law? I'm not aware of legislation that's pending in Wisconsin. And I have to admit, off the top of my head, I do not know all 50 states, but I will tell you this about Wisconsin. I was really surprised because Quarles and Brady is based in Milwaukee. And I was surprised to learn that Wisconsin is one of the more conservative states. Right now, I think they have the tiny medical marijuana law where you can have it for some conditions, a little tiny bit, but they don't have broader provisions. But I don't know what's in the legislature. How has OSHA reacted to the various state laws as it relates to safety? That's a really good question, and a lot of this still needs to be run down and boiled out. I'm not aware of any official proclamations from OSHA, but again, keep in mind, it's perfectly legal to have a policy that says you cannot possess or use in the workplace. You can't use at all. You can't be impaired, you can't have marijuana or any other drug with you, and you can't use it at all. And so that's what I would focus on. If you have a particular incident where somebody was high and it wasn't detected, I don't know what OSHA's going to do with that. If a driver tests positive for our driver position, not knowing when the candidate smoked or used, can we still decline the candidate for the position? I should say that again and say it so people can actually understand what I just said. If a driver tests positive for our driver position, not knowing when the candidate smoked or used, can we still decline the candidate for the position? Yeah, that's the whole safety sensitive thing. Right now, I'm advising clients that until we know otherwise, unless you are in New York City, if someone is driving as part of their job, that is a safety sensitive position. You can tell them that because they are a medical marijuana user or a marijuana user, that job's inappropriate for them because it's a safety sensitive position. And you can see if you have other positions. I always tell clients, man, be smart about how you do this. Tell them to apply for something else where it doesn't look like you have a hostility toward medical marijuana users or recreational users in states where it's lawful. Direct them to a job that would be more appropriate. What if the employer is in Wisconsin but employees live in another state? What law applies? It depends on where they work. Again, I'm so sorry for those of you who live in or touch California. California seems to think anybody who sets foot in their state, California law applies, although there have been some recent good cases that have cut that back. Otherwise, it is where the employee works. That's the law that applies. We have time for one more question. What if CBD use appears as THC on drug screen for safety-sensitive positions? I would enter the interactive process. I mean, we would not officially call it that, but that's what I would do is I would talk to the person. I don't know off the top of my head if that's how that tests. My understanding is CBD oil does not have THC in it, and so it shouldn't come back that way on a test. Confirm that with your testing company. if somebody has THC, it's a safety sensitive position. Right now, there's no state that requires you to put the person in that position. More cases to follow, more laws to follow, no doubt. But again, I would make sure you're getting a positive THC test for THC. Okay, I'm now being told that we are officially done. Thank you very much for attending, and we hope to see you all soon at the next Quarles and Brady infomercial type webinar and presentation.